If the will appoints you as the executor or personal representative of your loved one's estate, can you get out of it? Can you step down? Hi, I'm Guy DiMartino. I am a Northwest Indiana estate planning and probate lawyer, and today I would like to answer that question for you because it was recently asked of me. This was the situation. A person calls up and she is the named executor in her grandmother's will. She says, I do not have the time or the inclination or the ability to help administer the estate. And not only that, some of the people in the family are pretty difficult to deal with, and I don't have the temperament to deal with them. Can I step down? I said, yes, you can step down. I said, let's take a look at the will, because typically it would be easier if there was a second appointed executor or personal representative, which says if so-and-so cannot or is unable to go ahead and act as the executor, I would like so-and-so to be the executor of the will. So if there is a contingent or second line executor, it makes it easier, because you can just say, I disclaim, I'm going to step down. I don't want to be the executor. I don't have the time. Will you go ahead and do it? If they say yes, great. Then you have to follow the process for court in order to get the will admitted into probate and administer the estate. If you are the last line of the named executor, then when the stuff is filed in court, somebody would have to be going forward to be the executor or personal representative. Interested parties can go ahead and become the executor or personal representative as long as they meet the requirements. They're over 18 years old, they're not a felon, they have their mind, and whatever else is in the statute. You can even request that you have a professional act as the personal representative or the executor. There are sometimes trust departments and banks that'll do it. Lawyers will do it. An accountant will do it, as long as they are approved by the court. So interested parties can become appointed as long as they meet the requirements. Professionals can be appointed by the court as a special administrator or an executor of somebody's estate. So if you don't want to do it, fine. If there's somebody else that's listed in the will, even better. If not, somebody will need to petition the court and get appointed by the court as a special administrator or executor or personal representative. If you have any questions, you can always reach out to me. I am Guy DiMartino. Have yourself a great day.